Okay. I think we started recording. Okay,
Thank you.
sure, no problem. As I was saying, I've been in practice for 15 years. I am a certified specialist in this area of law of estate planning, trusts, and wills. I think you've read my bio if you haven't already. It's where my true heart lies, based on, especially after what we went through as a family with my mom when she fell ill. So I love having presentations like this where I could share information that I know, answer questions that you may have. So if anytime during the presentation, if something comes up that you'd like to ask a question on, please do ask. If it's something I would address later on, I might ask you to hold off until we get to that point. Okay. So if I may ask, start with asking who have plans now in place, something in place where you have made, okay, provisions for something that may happen in the future. So that's good to know. I hope after we have this conversation today that there'll be more hands that go up. The the most common misconceptions that I hear about when I meet with a client about estate planning, I've listed them on the page here. A lot of people presume that having estate planning is something that's only necessary if you have a lot of wealth. And to debunk that, I point out all of us have an estate here. If you own any assets, that's what the law would call an estate. And following that, a lot of people presume that estate planning is all about what happens after I pass away, and that's it. I would counter that a very important part of planning in advance is the life planning portion, where if an event of incapacity happens physically or mentally, that you have trusted persons in place to be able to step in for you. Then I think the most common misconception is some people, when they come to meet with me, say, I have a will, so I don't have to worry about probate. That's something I don't have to worry about. And unfortunately, having a will alone doesn't avoid probate. It's actually a document that has to go through the court system for your estate to be and affairs to be wrapped up. So then what is estate planning? What does it constitute? And I think it's important to define that from the get-go. It would be authorizing the persons you trust to certain positions of authority in writing, so that if and when the need arises for those trusted persons to act on your behalf, then they have the tools they need to be able to help you manage your affairs, your finances, to advocate for you when it comes to your healthcare decisions and preferences. And after you pass away, to carry out what your wishes are as they've been written down. I mean, I emphasize a lot on the writing portion because you could have as many conversations as you think may be necessary to make this happen, but realistically, without having things written down with your signature on it, it would be very hard for anyone to prove indeed that, yes, this is the person I would trust to go to the bank and manage things for me. So that's estate planning in a nutshell. The minimum life planning that I think all of us should have anytime you're 18 and over, is those two documents that are mentioned in the handout: a durable power of attorney and an advanced healthcare directive. You've probably been questioned a lot anytime you go see a doctor nowadays. If you're going to have any sort of procedure done, they'll ask you, do you have an advanced directive? Do we have a copy of it? Please let us know if something unexpected happens, who we can talk to, who would know about what kind of decisions you would like made on your behalf. The durable power of attorney is the same concept. If an event of incapacity happens, who do you trust to handle your finances for you instead of healthcare decisions? These are documents that could become very essential during your lifetime. It may also be never needed, right? It depends on how things unfold as your life unfolds. And if there's, one guarantee in life, that things will always change and things may not always happen in the sequence or in the way that we all hope and envision. So you protect against those unexpected situations by having the right documents in place. That's the minimum I would recommend. I mentioned that it's good to have more recently signed documents. Legally, these documents are meant to last as long as you don't revoke it or change it. Practically speaking, if you go to a bank and try to enforce a power of attorney, they'll say, well, we need something signed more recently. It has to be something within the 5 years. What they're trying to protect against is changes that may have occurred or preferences that may have changed. So, and it's also a good idea to revisit what you may have decided, 10, 15 years ago. Maybe it's not what you would have wanted or the persons you would have wanted in those trusted positions. There are plenty of free forms out there that you could look at, download, sign, and notarize to get them, make them official. I've cited just one site, which is the Sacramento County Law Library. We do have a special separate law library for these kind of purposes. They have a great deal of different forms that you could download and look at and use. Again, so there's no excuse for not having something done. I think the forms are pretty self-explanatory. They do come with good instructions. So if you haven't done so already, that's one place you can check. Yes, I'm sorry.
What's the source of that for the documents you just mentioned?
Yes, so that one of the sources is the Sacramento County Law Library. The website, the link is actually on the handout, the first page. And you could just Google.
Oh, okay.
Yeah, you could just Google that.
Okay, cool. Thank you.
Sure. For the advanced healthcare directives, there's different groups that publish their own versions. If you have Kaiser, for example, they have a very elaborate, I think 16, 17-page document that you can use. UC Regents also has one as well. The one that's at the Sacramento County Law Library is it's the statutory form, which means it's the bare bones kind of version, but it's just as good. It's valid. It may not be as detailed as the other forms. So any questions so far? Am I talking too fast? No? Okay, good. Probably the number one question I get when I meet with people about estate planning is what probate is. So everyone seems to understand it's a bad thing. You want to avoid it at all costs. And I'm not exactly sure why, but I was told, you want to make sure your estate doesn't have to go through probate. So it kind of gets a bad rap, but there's good reasons for it. Probate is the court supervised process where after someone has passed, someone else needs to go to court and ask to be appointed as the person in charge to collect all the assets of the person who passed, figure out who's owed money, make sure they're paid to the extent possible, figure out who the heirs are, the beneficiaries are of the person who passed, so that at the end of the process, those rightful heirs can inherit by distribution. The quickest, theoretically, a probate can wrap up is 9 months because of all the statutory waiting periods that are involved. Realistically, I would say it's closer to 1.5 years, if not more. So it's a lot for families to have to go through that before they could, while they're grieving, no less, after someone has passed, to get all the affairs wrapped up in a timely manner. The the reason for a process like probate is that the government wants to ensure, even after people pass away, that the economy can move on, right? Assets can go to where they need to go. Any disputes that might arise are taken care of all in one setting. But even with those reasons, the government says, we only need to have you come into court if your assets are greater than a certain amount. The probate pot, if you will, is bigger than $184,500. That's by statute. It's a fairly, and it's a amount that applies for each individual for all assets. If it's pertaining to real property assets, that limit is lower. It's 50,000. But you have to look at what actually goes into a probate pot for that calculation. It would be anything that's left in an individual's name that doesn't have somewhere else to go by contract, which is beneficiary designations or pay on death designations, or even on transfer on death deeds for properties. That's not already jointly owned with right of survivorship, meaning somebody else will inherit automatically without having to go through court, or it's owned through a revocable living inter vivos trust. Any of those names, it all means the same kind of trust, the most common kind. And I'll go into a little bit more detail of how those kind of trusts work later on. So if you have questions about that, we'll address them. So if probate is necessary, then most likely you're looking at a public, lengthy, costly administration that involves the court system to clear title to everything that was owned by someone who's passed away. Most people don't like that aspect, don't like the thought of having to go to court or having things, dragging things out when they want to settle things as quickly as possible. So it could still be the best appropriate administration if there is going to be a fight anyway, if there's going to be, if people are going to be suing in court anyway, maybe that's where you just need to start the administration. But I would say in a vast majority of cases, people are not looking to litigate. So I mentioned a couple of different ways where when you're calculating that probate pot, you decide what goes into that pot to decide whether or not there's going to be a probate needed or not. A lot of married couples will ask me, hey, we own everything jointly. Everything's in both our names with right of survivorship. Do we have to worry about probate? And to be fair, I say not at the first passing, because everything will go to the surviving spouse, right? If it's jointly owned. But you still have the problem after the first death. What happens with the assets that are just now sitting in the surviving spouse's name? Now that triggers all the things that we talked about the probate pot. So it's planning, but it's incomplete planning, right? To own everything jointly. Similar things could happen with beneficiary designations or pay on death designations. A lot of people will tell me we have our children named, I have my spouse named, so we should be good. It's amazing how many clients that contact me saying, you know, someone passed away, they had beneficiary designations on them, but they never updated it. You know, never got around to looking at it. It still had their parents' name on it who died, 30 years ago. Those are all well-intentioned, but still ways that someone could end up in probate court to try to clear title to those kind of assets. Let's see.
We found out there is one probate judge for Placer County. So if you wind up in probate, get in line with everybody else in Placer County.
Yeah. So a lot of the delay is, yes, that's true.
I didn't hear what you said.
So Placer County, it's, probates are handled by county, and Placer County has one judge. And so a lot of the delay in probate comes from having to deal with the court's calendar, right? Uh, Whenever I meet with someone about opening a probate administration, I have to explain, we submit the paperwork to open probate. Then the court says, very good, come back in 3 months. And then we'll see if you can open probate or not. In Sacramento, that time has shortened a bit because they've made adjustments. They had such a backlog after COVID that they've added commissioners to help with the workload. So that initial petition now takes a month and a half or 2 months. But still, it's still a long time to wait to even have the paperwork in hand that would authorize the person to go out and handle things. Everything gets frozen until you get those court documents.
My brother-in-law passed away near last Valentine's. His probate finally closes February 9th, almost a year. Mostly, we've just been waiting for the probate judge calendar.
Yes. So I don't know if everybody heard that comment, but someone was mentioning how a probate administration was taking almost a year from open to close, and I would say that's not bad. That's not bad, I'm sorry to say. So like I said, 9 months is probably the shortest time you could take. So a year, 3 months more, that's not ideal, but it's not bad in comparison to how long it could take. So one planning that I recommend for everyone, similar to make sure you have durable powers attorney, advanced healthcare directives, is to check up on all the beneficiary designations that you have on retirement accounts, on pensions, on annuities, life insurance policies. You may have said it and forgotten about it many, many years ago. I get situations where they have ex-spouses listed, where they have parents listed who passed away a long time ago, or even if the primary beneficiary is designated to the person you would want, you could always make sure you have a backup. If not one backup, then additional backups. Because again, and this would be a common theme I reiterate time and again, life doesn't always unfold the way you envision. I see plenty of parents whose children have passed away before them. And one of the things we make sure we do is check on those beneficiary designations, because I'm pretty sure we need to go update them. So that's one thing I would like all of you to do, whenever you get a chance. And no, it's okay, go ahead.
If you didn't have a person in place, like say, you're the only child or whatever, just like say we go up to your law firm, can a law firm be this, where it has to be someone, a relative or a friend or somebody who does it?
Do you mean as beneficiary or to help you handle an estate?
Like, okay, so you have to have a beneficiary. I mean, you have someone of your choosing.
To help carry out your wishes. Yes, usually there's someone either designated in the documents that you have in place. If you don't have documents, someone will go to court and ask to be appointed. There's an order of priority that the court likes to see, usually your closest blood relatives, spouse first, children, grandchildren, things like that. And I'm just mentioning probate. But it could be anyone that says, I will do it. It could be a creditor. If no one opens probate for a decedent, but someone is owed money, that creditor can go to court and say, I'm never going to get paid unless I open probate. And they can do that. And whoever is acting can go through probate without legal assistance, but most seek out legal assistance to do so. I thought your question was more about
Yeah, I was thinking more state. That's okay.
that did remind me, though, I should mention another way people sometimes end up in court, even though they did everything right, is say it's a husband and wife, they had a life insurance policy, they only had named each other on their policies as primary beneficiaries, as you tend to do. and they pass away together. So they made sure they had valid beneficiary designations on those accounts, but there's no living beneficiary to inherit if they pass away together. That would end up in probate to get cleared. It could go naturally to their children, but it would have to go through probate for that to happen. So if they had just had those children listed in the secondary positions to begin with, then there wouldn't have to be a probate proceeding at all. I want to go back a little bit to the idea that this is the pushback I get a lot from married couples, where they say, we own everything jointly, we don't have to do anything now. And, you know, after one of us passes and one of us, you know, the survivor ends up with everything, that person can then do the planning at that point, which is true. Assuming that that person is capable and able to sign legal documents like this, to make plans, and doesn't have an event of incapacity themselves. It also assumes that one would pass before the other and not together. I think that's a dangerous assumption to make, that you will be available and able to make plans later. There used to be a rotisserie oven that sold in the late 1990s that the slogan was "set it and forget it." So I just dated myself, but it's not too far back. Estate plans, you know, it's something you have to revisit every couple of years to make sure what you've written down still makes sense in light of changes in circumstances, changes in wishes, changes in your trusted persons, perhaps. And so that is something I like to emphasize in somewhere in my presentations. Another common situation that comes up, I have parents that say, okay, I'm the surviving spouse, I own everything, I still don't want to make any plans, but I do want to avoid probate. So I've added a child or children to my house or to my rental, and that would take care of it. Hopefully I meet with these people before they make that change. Sometimes I meet with them after they made the change, and I have to have the unpleasant conversation of what that means, because there's consequences that they may not have thought of. What I mean by that is they're trying to avoid probate. That was their number one goal in creating a joint ownership in something. But there's consequences that happen with property tax, with capital gains tax, with maybe even income tax if it's a rental that was producing income. By sharing ownership in something now, that may have that could affect all of those factors. Then that's just the tax considerations.
Could you explain that more? Why does it change?
Yeah, so on the second page of the handout, there's a little colorful chart. Illustrates the situation where a home was purchased by a parent in 2014, and then now it's in 2024, the fair market value has gone up from the initial cost of 100,000 to 300,000. The assessed value for property tax purposes, because of Prop 13, it could only increase a certain percentage per year. It wouldn't go up as high as fair market value. That's commonly what happens here in California. So if a parent says, just say it's one parent, and the parent wants to make sure that that house doesn't have to go through probate. And so they add child A to the trust as a joint tenant. Joint tenant means there's right of survivorship, assuming that the parent passes away before the child would inherit 100% of the property. What the parent has done, though, is made a lifetime gift of half of the value of the home and created a joint ownership. So part of the danger is now you're both owning the property, if either the parent or the child has creditor issues, then that's assets that they could come after. Whether that be you could have the most financially responsible child who gets into a car accident, and now they're looking for assets to fulfill whatever judgment. So it may be not intentional, certainly not something you would have possibly considered. So there's dangers of joint ownership. If that was a rental, then, and the parent was perhaps, relying on the rental that came in from the property, their thought may have been, I just want to make sure it doesn't have to go through probate, but they've actually just transferred ownership. Half of the ownership, half of the benefit of that rental income that should now go to the child. Probably not something that they intended. And going back to that calculation, the difference in the cost basis versus assessed value and fair market value. If you sell that, if the parent were to sell that house, there would be a capital gains tax. So if you buy a house for 100,000, now it's worth 300,000. That's not income, that's capital gains. So if the parent sold that house, there would be tax on that $200,000 appreciation in value. If the parent gifts something during lifetime, the recipient child inherits the cost basis as well. So the basis in the parent's hand carries over to the child. So if the child later sells the home, they have to calculate appreciation from that $100,000 value on the house that's in the illustration. Compare that to the situation where the parent passes away and the house then goes to the child after death. At someone's passing, the basis in the house gets stepped up to the fair market value of the house at the date of death. So the child could turn around with the inherited property and sell it. Zero capital gains tax. That could be a huge difference. And if a parent makes a lifetime gift without thinking of those kind of consequences, that could be more money lost to taxes, which nobody ever likes. So that's, I
The
mean,
best scenario is to be a co-owner and have the parent die, and then the kid is just now the owner, and he, like you said, he doesn't have to pay an inheritance tax nor capital gains if he does sell it because of the difference in the fair market value. Do I have that right?
no, so for capital gains tax considerations, it's better to hold on to the property. It's better for the parent to pass it on due to death, not from lifetime gift. Does that make sense? So a parent might not have known that or thought about that when they just added a child to their name on the deed. The other difference in the property tax, there was a big to-do a couple of years back with Prop 19 and the changes that came with the parent-child exclusion from property tax reassessment. So until a couple of years ago, if a parent could pass on their primary residence in addition to $1 million of additional other property that's not residential, right? That's not their primary residence, without triggering a reassessment for property tax purposes. So you just have to file an exemption and tell the assessor what was happening, and then the property tax rate would say essentially it's the same as in the parent's hands as in the child's hands after the change. So 2 years ago, that exemption has been reduced very, very small in that only the principal residence can be transferred. The recipient child or one of the recipient children has to come live in the home and use it as their family home. And the exemption is limited to $1 million, essentially. That anything above that difference then would be reassessed. So if a parent makes a change in title to their home or a rental home, or thinking I'm just going to add the child and make sure I avoid probate, that unless the child lives in the home with them, that transfer wouldn't qualify for the exemption anymore. And suddenly you get a tax bill that's higher. And that's not reversible. You can't say, oh, I take that back.
I mean, the child may not be the
Right.
forces.
Yes. So unfortunately, the exemption has been reduced to and very limited to family homes only that are maintained and continued on as family homes to continue qualifying for this parent-child exclusion. Any questions on that? I went over that kind of quickly.
Well, I'm guessing every case is different.
Yes.
But in general, most of the time, you counsel people to have co-ownership or to do the gifting thing.
I counsel against co-ownership during lifetime unless there's other reasons for doing so, and only with full discussion and understanding of all the different implications of such a change. Because of the step up in basis that happens at death, and because most parents wouldn't qualify for that parent-child exclusion for property tax changes, and nowadays it's most of the time, I can't say all, most of the time it's beneficial to hold on to property until death has occurred for it to be passed on.
But then there's inheritance tax to deal with.
Inheritance tax, it's not on the recipient. So, and there's no inheritance tax in California. The only tax you'd have to be concerned about is gift or estate tax at the federal level. And at the bottom of page 2, it shows what the rates are for gift and estate tax right now. And right now, you could pass along more than 13 million during your lifetime and at death without worrying about gift or estate tax. So most people don't have to worry about that. It is, if you're worried about that, we could have further conversations. It is scheduled to change at the end of 2025. It drops down to a mere 6 million, which is still pretty large. But that's only until Congress decides to make further changes. So with that, we don't know what could happen in the future. I put that chart in there to historically to show you, you know, as less than 30 years ago, that exemption was 600,000. Right now it's been inflated to 13 million, but we don't know what Congress will do next. There's been talk about getting rid of the step up in basis, which would affect everybody, no matter how much wealth you have. So if you get rid of the step up in basis because of someone's passing, everyone would get taxed. Yes.
Susan, I have a question. What about in bank assets, accounts?
Mm-hmm.
What do you recommend as far as, okay, all this money is here locked in this, and this? How do we make sure a child or children have access to that?
Great question.
Could you repeat it?
So the question was, how do you ensure that your heirs or children have access to assets like bank accounts? And so two different answers here. So having the two documents I mentioned before, durable power of attorney, and well, advanced healthcare director for healthcare decisions, but the durable power of attorney would allow your child access to be able to assist you during lifetime. A power of attorney only lasts as long as you are alive. So to address what happens after you pass away, that's when you have to think about doing a more advanced planning, either a will or a revocable living trust. I lean towards doing a revocable living trust because it is something that takes effect as soon as you sign it. So during your lifetime, and also continues on after your passing, to allow those people you authorize in those positions of authority to handle things for you during your lifetime and after death.
I'm sorry, Susan, what's the name of that type of trust again? Is it the same one that you have?
I have it, yeah, I mentioned it a couple of different times because it's known by different names. Revocable trust, living trust, inter vivos trust. All of those mentioned that it's the same concept. And now might be a good time to just go over what that means. There's a diagram on the second page that I like thinking about things visually. So a revocable living trust, whatever name you call it, is essentially an agreement that you make with yourself. It's a pretty lengthy document, and you split yourself up into these 3 artificial roles. You're the grantor or the creator or settlor. There's different names, but you're the creator of the trust. You're the trustee initially, who has the rights to manage everything that's in the trust, and you're the beneficiary. It's still all your stuff. You could revoke the trust at any time and get rid of it, which is why it's called a revocable trust. So you make an agreement as the creator with the trustee, which is still you initially, to say, I'm going to give you all of these assets. You're going to manage those assets for my benefit as the sole beneficiary during my lifetime. And you have all these fiduciary duties you have to abide by. When you fill all 3 roles, there's really nothing that changes about how you manage your own assets. Before you even put it into the trust, you owned it, you benefited from it, you had rights to manage it any way you wished. That continues even after you transfer things into a revocable trust. The advantage is the agreement also has all these provisions about what kind of responsibilities the trustee owes to the creator, what happens when the creator becomes incapacitated, and what happens after the creator has passed away. And so if you become unable to act, you have trusted persons named in the document waiting in the wings to step in to your shoes as a trustee. Still 100% for your benefit, according to what the trust agreement says, but you've provided someone else to come in that you trust to come in and handle things for you. After you pass away, because the creator has now passed away, the trust can no longer be changed. At that point, it becomes irrevocable. The beneficiaries is no longer you because you're gone, but you have designated in the agreement who gets your stuff after you're gone. And the trustee, whoever is acting, would have to carry out your wishes according to all those fiduciary duties again. They have to be, so I could go through a little bit more about what the duties mean, but basically they are bound by the provisions you have put into your trust agreement. So if you own assets through the revocable trust during your lifetime, then whatever is in that trust does not count for the probate pot purposes. The government essentially is saying, oh, you've made your own provisions about who's going to take care of your assets when you're gone, who it's going to go to. They're bound by these fiduciary duties to carry out your wishes. The court doesn't have to get involved at all. Hopefully. Litigation is one way that a trust could still end up in court. But to keep things simpler, any assets that are held in a revocable trust would not count. You wouldn't put it in the probate pot. As I mentioned, people with revocable trusts, their estates could still end up in probate because of beneficiary designations that weren't done properly, because they created a trust 30 years ago and kept nothing in it. That happens pretty frequently, where I'll meet with somebody who's had a trust that created 20 years ago. They switched a couple houses since then. They opened accounts at new banks, never put those assets in a trust. So if they had passed away before they came to see me, that would have required a trip to court to say, let's get these assets transferred into the trust. Am I running long? Okay, I'm okay.
You're okay.
Okay. So barring those situations where you don't keep up with your estate plan after you created it, it should be that the revocable trust is there for the persons you trust and you named as trustee, to carry out your wishes as you put forth in the agreement.
So keeping up with it means if you buy another house, you have to make sure you add it to it or whatever. it might be.
Yeah, so what commonly happens is when you first create a trust, the attorney should help you transfer title from Susan individually to Susan as trustee of her trust. What sometimes happens is Susan goes out, sells the home, gets a new home, and titles it to Susan as an individual. That's not in the trust anymore. And usually your home is your biggest asset. So you want to make sure when you get the new home, just put it to Susan as trustee. And that would be in the name of the trust, even if it's not listed on the trust schedule as a specific asset of the trust. Okay. So if you have a trust now, go check to see what, make sure all your assets are titled to the trust. The only things that wouldn't change title to the trust during your lifetime would be things like retirement accounts, annuities, life insurance policies. Those we already said would pass by beneficiary designation. And the trust could be one of the backup beneficiaries that you list. That's double, triple. Yeah.
And if you have those retirement accounts with designated beneficiaries, that doesn't have to go through probate.
Correct. So the question was, if you have valid beneficiaries designated to inherit something like a retirement account, it wouldn't be part of the probate pot.
So what goes into the probate pot is everything that's not in your trust.
Not in your trust, not contracted to go somewhere else, like in a beneficiary designation, and not jointly owned with right of survivorship. So a lot of married couples will own property as joint tenants or community property with right of survivorship. That means when one person passes, whoever is left will inherit that person's share. But of course, that would require one person to pass away before the other, and it might necessarily be in the order you wish, if it's in the case of a parent or a child. And it wouldn't address situations where a couple passes away together, because there's no beneficiary at that point. There's no survivor to inherit.
So do people have this revocable trust as well as a will, or is this taking?
That's a great question. Having a revocable trust is, for a great many people, the most comprehensive way to address all those possible contingencies and avoid probate and make sure things are taken care of. But there are always situations where people don't fund it properly or keep things funded in the trust. So as a safety net, you always have a pour over will with a trust. And the pour over will is exactly as it sounds. It's a simpler document that says, I have a trust. If I happen to leave anything outside my trust during my lifetime, when I pass away, I want it to go to the trust. That still requires a trip to probate to carry out that wish in the will, but it would not be a full probate administration. It would be a shorter petition to ask the court, they really meant to put it in. Can you help us to get it transferred into the trust? And then we could go away, not take up the court's time, and handle the administration on our own.
What was that called again?
It's a pour over will. It's not called a pour over will. That's the substance of that type of will. Because if you have a will without a trust, the will would do a lot of the things that a trust would do. It would name who's going to be in charge. It would say who gets what after you pass away. But it would go through probate and it would become a public document. Your nosy neighbor would know who's getting your stuff. So that's a major difference between a trust and a will.
Probate is public, right?
Yes.
So anybody can look at what's going on with the estate.
Yes, anything that's filed with the court, anyone can go and get a copy of.
So when you say nosy neighbor,
Yeah. I my first boss that I worked for got Marilyn Monroe's will. And he would show everybody, I have, any celebrity, you can go to court and get their will, if it's a will, yeah.
Is that, with probate, is that when you have to advertise it or something in the or public, whatever. I remember when my dad died. I remember it had to be an announcement or something.
Yes, it has to be published in a newspaper of general circulation in the county that the person passed away. That's a very archaic way of doing things now. People don't get papers, especially physical. But not the newspapers will publish it online as well. But yeah, it's an archaic leftover requirement that you give everybody notice, everybody possible notice that there is a probate that's being opened. If you have a claim against this person's estate, come forward now, or you're gonna be, you forever hold your peace. Yeah.
Years ago, I worked in the bank, it was mid-70s. One of my jobs was to go through the fees probate section and compare it to our customer list. So I could give it to the trust department so they can then do their paperwork. And every day I had to look at the bees probate thing to find out if I had a customer in this public notification.
And so the comment was that, that someone at the bank had to check the obituaries and compare to their client list to make sure, customer list to make sure, they're aware of what was happening with their customers. That happens automatically now at this point, probably. Yeah, so
This was before computers.
yes, now there's computers, there's computers probably who go through the announcements like obituaries and legal publications like announcements for probate. But yeah, anytime I file for a probate, it has my name and address, and I get all sorts of mailings about, do you need help selling a home?
Yeah.
So yeah, it's a very public process in that way.
Creditors could make claims.
Yes, so creditors could, the part of the reasoning for publication is to make sure not just the creditors that are like credit cards or mortgage lenders, but someone who may have privately borrowed money or loaned money could be notified ideally. That's the idea behind publication. I do want to reiterate that a revocable living trust is a good plan, a good document to include in your estate plan for most people. It's not always the right choice. So depending on the circumstances, you may not need it. It's usually the most complicated way to set up a trust, to set up an estate plan. I'd say make sure you have a durable power of attorney, advance healthcare directive. If you want to change the default that would apply under the law, then do at least a will. And if you want a comprehensive way to make sure avoiding probate and things are handled the way you wish, then you may consider doing a revocable trust. It's not an end-all be-all solution. So it's certainly worth considering, but don't feel like you have to do it or you're not doing the correct thing.
So what is it that triggers probate?
It's the amount of assets that you have in your name that are not already going somewhere else due to joint ownership or beneficiary designation, and is not in something like a revocable trust. So the threshold is $184,500.
You have more than that.
If you have more than that, that's still in your individual name. Yes.
So a person has less than that, it never even goes to probate.
Probate is not required. It could still be opened, but the law provides shortcut methods where those who have rights to that money can claim it under an affidavit, under sworn penalty of perjury statement. So what sometimes happens is I get calls from children or someone that says, my dad didn't have enough assets to require probate, but there's a bank account that's like $80,000. What do I do to collect it? They just have to wait 40 days, bring a death certificate to the bank. They'll have an affidavit that says, I swear under penalty of perjury that there isn't enough assets to require probate, and I am the person who has the utmost rights to this money. Sometimes there's concerns that the wrong person will get to the bank first, and it'll be whoever comes first would and be willing to sign that statement under penalty of perjury that they could get the money. So I've had a few situations where we had to make sure that the correct person is at the bank collecting that money.
And that's because there was a trust in place or there was not one?
Even if there is a trust in place, you could still have that one account that didn't make it into the trust. And if it's not over the threshold, they could, the trustee hopefully can still sign a statement like that to say probate is not needed because the bulk of the estate is in a trust. It's only this one account that's left over under the threshold amount. So the affidavit procedure can be used to collect that asset and hopefully fund it into the trust. So if you have an existing trust, make sure, I'd recommend please check to make sure all your assets are correctly titled to the trust, that it still reflects your wishes as to the persons in charge and what you want to have happen after you're gone. A particular note for any joint trust created before 2000, it was the case that back then, when the exemption amount from gift and estate taxes were as low as 600,000, and a lot of people were facing the reality of having to pay gift or estate tax after they passed away. Joint trusts were structured so that after the first spouse passed away, half of the estate that belonged to the first spouse who passed away would be locked up so that they could use that exemption amount when the first person passed. And locked up meaning it was not within the survivor's full ownership and control. And that was, the goal of that structure was to, try to minimize gift or estate tax. Because if the spouse got everything, then that's when the second spouse passed away, then there could be estate tax that could have been avoided otherwise. The law has changed a lot over the last 25 years. The exemption amount is larger. There's a concept called portability that came into the law that says if one spouse doesn't use their exemption, the second spouse can take it and claim it as their own. So the reason for this kind of forced division of assets after the first spouse's passing is obsolete in a lot of ways. It's still used sometimes for blended family situations where a couple with children from different marriages come together and they say, I want my half to go exactly here. I want my half to go exactly here. So there's still valid reasons why you would use a structure like that. But just last week, I met with a client who had a trust for 30 years with her late husband who is now passed. And she's very sophisticated, has a lot of assets. And she said, I could have sworn the trust said, I get everything and manage it. And the trust was created back before 2000. It had that AB structure that was that would divide the assets. And at the death, when her husband passed, and forced an irrevocable trust. And I had the very unpleasant task to explain this trust that you created with your husband. Now, you have to honor what the document says because you had made a promise to each other. This is how things would be carried out. And now that your partner is gone, you can't change what it says there without a lot of effort. So, that gave me the idea to make sure if you have, to point out here, if you have an older trust, take a look at that specifically to see if it forces a division of assets, because most chances are it doesn't make sense to keep that.
So in that example, that meant his kids got something that she thought she had rights to?
No, though there should have been a division of assets that happened so that half of it would be guaranteed to go to the beneficiaries that they had agreed on. And the surviving spouse's half could go anywhere. And it's probably going to the same people anyway. But the trust says this should have happened. And those who may have a problem with that not being carried out might be the beneficiaries that who would have received under the first spouse's death. And unfortunately, the IRS, because irrevocable trusts are taxed differently. And so the IRS might be missing out on additional tax that from the irrevocable portion of the trust. So, yeah, those are not pleasant conversations to have.
So when someone passes, is it? I guess, do they really have to know this information to the person, or do they have to I mean, what does it say, contact, say you're the attorney, that you for a firm, they contact you, or do you know, and then?
I wouldn't know. I usually do get contacted from the heirs of the person for whom I made plans. I mean, my contact information is included with everything. But they could also go to any attorney if the heir or the child, in most cases, already has a planner of their own, then they can go to any attorney to get assistance. If someone passes away without any documents, then you'd be looking for anyone who would help you handle a probate administration. So, which could be me, but which could be a lot of other attorneys as well.
And was it, when it goes to probate, is it a standard? Let's say fee, whatever, or it depends?
Oh, I'm glad you pointed that out, because on the top of page 2 is the statutory fees. So the government decided we want to make sure probate happens and that people will assist where needed. So people meaning usually attorneys. These are the statutory fees that would apply for anyone who acts as the attorney for the administrator or executor or whatever the correct term is, and possibly for whoever acts as administrator or executor, unless the will says otherwise. So it's based on how many the amount of assets that are actually goes through probate. So the first $100,000, it would be 4%, which is 4,000. The next $100,000 of value, it'd be 3%, which is 3,000. So if you have $200,000 worth of assets, we're already talking about $7,000. And this is where I like to point out, you know, when you talk to any attorney about doing advanced planning, it's not going to be as high as that, or it shouldn't be as high as that. So if you have assets more than 200,000, you should be looking at planning and not having to go through probate.
Who gets these fees?
So this is set out for whoever acts as attorney, but whoever acts as administrator could potentially also collect the same amount. So if you have a $200,000 estate, you have an attorney and someone who acts as the person in charge, that's $13,000 per, I'm sorry, that would be $7,000 per individual, the attorney and the person in charge, which would be 14,000. So that's how much less your heirs would inherit.
So do attorneys make a lot of money in probate fees?
Sometimes it's not the best situation. So I had one probate where someone had a home in the Bay Area. You can imagine how much that house was worth. I didn't have as much work to do because that was really the only asset in the estate. So I agreed to less than the statutory fees because the court also wants to make sure you're earning reasonable fees. That just because you have an asset that happens to be very high value, if you don't do that much work, you can't claim the statutory fees. But these fees exist to encourage attorneys to help.
Is there a fee for the trustee?
There could be, it depends on what the trust says. Most trusts will say reasonable fees may be collected. But I think it's for the trust I draft, unless someone says, I absolutely want to make sure this person is paid, they might not want to receive payment because it's taxable wages. Yeah. And a lot of executors or administrators choose not to get paid either for the same reason. If they're going to inherit it anyway, especially if we're one of the beneficiaries, if they're going to inherit it anyway without any tax, why would you want to get some of that as taxable income? Is there any questions? I think I went over time. Sorry.
It's mind-boggling.
I know. I'm sorry.
No, you're fine. She has to drive back to San Jose.
Oh,
Thank you.
Sure.
Very helpful.
sure,
for
no
coming
problem.
So I never realized, so the purpose of the probate is to make sure that all the taxes that were possible get accrued. And it's attorney's job to find all that, which is why the attorney gets this probate fee, I'm guessing, right? Is that?
Well, no, the attorney's job is to assist the administrator or executor, whoever's in charge, to either carry out the terms of the will, if there is a will, or to collect all the assets, pay all the debts, and make sure whoever is identified as the correct heirs get whatever is left. So the government's interest is making sure keeping the economy going. So there's no assets or property sitting out there in a deceased person's name, right? And until it gets to where it should go.
Like, her handout, are you gonna have it? Or
Yeah,
you-
I'm gonna email it.
Okay.
So it has my contact information. If anyone has any questions, I'm happy to talk things over more. I don't think there's any questions for Zoom.
Could you email this handout for people who are not attending in person?
You bet.
Thank you.
Let's look at that.
You say, oh, go ahead.
If I wanted to loan money to a child or a grandchild, they don't have to pay back except out of their inheritance.
Mhm.
Know what I'm saying?
Yes.
So if I create a document for the trustee that is signed by me and witnessed, is that sufficient to say, this is what I want, you don't have to pay these back until you work it out at the end?
You should probably have that language in the trust as well, too, so that there's understanding and something in writing that says, yes,
You have to put it-
yeah.
Thank you, Susan. This is
Sure.
Great.
Or is-
Any Zoom questions out there?
And I'm happy to take questions after too, if you have a
I'm gonna
more
end the
detailed
Zoom
question you'd like
portion
to
here,
ask.
guys.
Thank you very much. It's really, really excellent. Even, and I have all these things, but there's still new information every time. So
Oh, good, good.
thank
Glad to help.
you. Thank you.
Sure.
Thank you. Thank you.
When you say you can answer questions, do you mean you personally, or your firm, or your office, or?
Well, I'm gonna stick around for a little while. I'm only right there. So, and you could always call or email me as well. It would be me.
Okay. Oh, so email is fine.
Yes.
Yeah, that's great. So do you come to Sacramento every day?
Pretty much, yeah. There's certain days where we have things happening with scouts or
Uh-huh.
school, and yeah, I telework, but most of the time I like to be here. Most people, I think, especially after COVID, prefer to meet in person, so, yeah.
I really appreciate you coming. Her office is right. down.
It's very handy.
Yeah.
Maybe visit.
No parking issues either. That's been really cool.
Yeah.
Thank you.
Yeah,
Sure.
yeah, thank you so much.
Should I end the meeting? It's still going.
Can
Okay,
see.
sure.
And it was being recorded, did you? see that?
Yes,